Press start recording. Ready to go? Yep. Hi everyone. How are you going? My name's Shannon Dakin. I'm on the Flipper board. On behalf of the board, I'd like to welcome everyone here who's here on the night, and also all the wonderful people that are on the webinar. Everyone on the webinar, you'll see to the right there's just a chat box there, and if you'd like to ask His Honour a question, or if you're experiencing any technological issues, please just type it in there and Caroline will assist you, and also let His Honour know. So we're lucky with most Twilight seminars, the people that we have on the stage don't need any introduction, and His Honour's no exception to that. Since his appointment to the, as it then was, Federal Magistrates Court and now the Federal Circuit Court over 10 years ago, most people in this room would have appeared before His Honour. So I'd like to invite him up. His Honour Judge Jarrett, please welcome him.
Can I get rid of that?
You're ready to go. Do you want to just move that?
Move it away, yeah.
You just move I'll work that out. I'll work it out by you start.
I'd also just say that we'd like to keep it interactive tonight, so if anyone has any questions, just put your hand up.
Do you mind?
That's
okay, yeah. That's your camera there.
Oh,
so, yeah.
Thanks for coming. Thanks for asking me to speak to you. I'm more than happy to do that. Most of you have been in court, but I'm more than happy to talk about it, at least. The flyer that I got round said I was talking about, I was going to be entertaining. Well, you'll be disappointed. You might be lucky enough to learn something, I'm not sure. I'm sure a lot of what I'm about to tell you, you've heard before or you've seen before. So if I bore you by telling you stuff that you already know, I'm sorry about that. This talk had its genesis in some discussions that I had with some other judges and practitioners about, I guess, just the day-to-day things that happen in court, the mundane things that happen, the way people announce their appearances, the way they do this, the way they do that. And we lamented that there really wasn't an opportunity for practitioners these days to get some experience in how to do the day-to-day things. When we all started, we were article clerks and we got to sit on our backsides in court next to the likes of John Byrne or Margaret Wilson or Margaret White, or you can name any of the Supreme Court or District Court judges really. And you got to see how things were done, and back in those days it was before judges like Justice Shepardson or Justice Barrington or Judge McLaughlin, pick either one, there were two in the District Court, Judge Kinney, and the list goes on, and they all had, they were all old-style judges and old-style advocates when they were at the bar. And so you learnt how things were done then. But things have moved on, times have changed of course, and the practices back then aren't all appropriate now. But a lot of the practices that were developed or that I saw back then have a particular reason for having been developed. There's a reason for things to happen the way they do. And sometimes we lose sight of the reasons and we think that the practices are arcane and out of date. But they nonetheless perform an important function. And I'll talk about a couple of those shortly. So what I thought I might try and achieve in the next little while is to run you through a first court date in the Federal Circuit Court from a while ago. And a lot of the things will be able to be applied generally across the board to any appearance anywhere. But some of them will be nuanced towards the Federal Circuit Court. So, and you will have heard a lot of this before, I'm sure. So the first thing that I wanted to talk about in appearing in court is why you're there. It's remarkable the number of people that come into my courtroom and don't know why they're there. It's true. Applicants can't tell you what orders they want you to make. And it's really quite fundamental. You need to know why you're there. Because if you can't tell the judge straight away what orders you want that judge to make, then you're behind the eight ball from the get-go. And if you think about why you're in court at all, you'll know that the last person you need to get offside is the person deciding the case. Why are you in court? What's the function of you as a lawyer in court? What's your ultimate gain? Anybody want to have a stab at that?
Advance your client's interest.
Sorry?
Advance your client's interest.
But how do you do that? How do you advance your client's interests in court?
You have to know what they are first.
Sure, you have to know what they are. But ultimately, the end game is convincing the decision maker, and it doesn't matter whether you're in my court or in the Supreme Court or in the Dairy Industries Appeals Tribunal, which I used to love appearing in, or the Fisheries Industries or the Retail Shop Leases Tribunal or anywhere else. All those things have been taken over by the QCATs of this world now. It doesn't matter where you appear. Your job is to convince that decision maker to make the decision that your client wants. That's it. Nothing more, nothing less. And if you're a respondent, it's the same. My client wants this decision made, so my job is to convince that person to make that decision. It's about persuasion and advocacy. And if you get the decision maker offside from the start, your job's going to be that much more difficult. So when they say to you, what orders do you want me to make? You should be able to give them to them. Just like that. Precisely too. Precision is important. The next question you need to be, and this is as a respondent as well, you'll ask for orders in your response. The next thing you need to be able to answer is how you can give the court, or how the judge can give your client the relief that they want. How does the judge have jurisdiction to make these orders? And how does the court have power to make these orders? Now these are basic things, yeah? None of this should be a surprise. But again, I lose track of the number of times I ask people to tell me, well, have I really got jurisdiction to do that? And they can't tell you. And in a federal court, that's really important because a federal court has no general jurisdiction. It doesn't matter whether you're in our court or the family court or the federal court. There is no general jurisdiction in Commonwealth courts like there is in the state Supreme Court. So we need to have a statutory authority to have jurisdiction and to give us power to do what it is that we do. And if you can't find a statute that gives us a jurisdiction, and you can't find statutes or rules that give us power, then we can't do anything. It's as simple as that. We sometimes get what's called associated jurisdiction through section 19, I think, or 18 of the Federal Circuit Court Act, and there's a similar section in the Federal Court Act and the Family Law Act. And that attracts to the court jurisdiction in claims that we wouldn't otherwise have jurisdiction in because we're seized of a federal matter. And there's a really interesting decision of Justice Forrest. I can't helpfully remember the name right now, but it's only in the last few years and it's about removing caveats. And I used to take the view that I can't order the removal of a caveat because I'm not a state court, and you looked at the Land Titles Act and it vested that power in the Supreme Court of Queensland. And so I assiduously applied the rule, but if you want me to order the Registrar of Titles to remove a caveat, I can't do it and I won't. I could order a party to cause a caveat to be removed. That's an in personam rule against a party using the injunctive powers in section 114 of the Family Law Act. And I could do that, but not the other. Justice Forrest wrote a really lovely judgment about the investiture of federal courts with state jurisdiction, and he drew on some comments by Justice French, Chief Justice French in the High Court and some other cases to conclude that we can actually order the Registrar of Titles here under the Land Titles Act to remove a caveat, for example. So you need to think about those things. It's not going to be an important issue in every case, and in fact, in most cases, it won't be. But there will be a case that comes along where it is important, and you need to be able to answer it in every case. Try finding the section in the Family Law Act that gives us jurisdiction in parenting cases. Ever tried to do that? No? You should have. In every case I just got through telling you that. It's pretty tough. It's pretty tricky to find. Have a look at it tomorrow morning. So I'll be asking. I'm in duty. So that's the second thing. Know where your jurisdiction and power is. If you know those things, what you want and how the court can give it to you in terms of its jurisdiction and power, and you're not at the bar table, fluffing around, making everybody wait for you, then you're on the front foot. And if your opponent can't do those things, well, you're at an advantage already. Let's talk about a few things outside of court. First thing is don't be late. Shouldn't have to say that, but things happen. I understand that. Don't be in two courts at once. Again, really difficult not to do, but don't expect the judge to wait for you. I know in my own practice, as probably some of you know, I won't wait for you. If it's at the end, there's nothing more troublesome to the judge if at the end of a list you've got one or two matters to deal with and nobody's there, and you've got a bunch of work back in your chambers to get done, and you've got to go up and down a wretched lift waiting for people to turn up. It's a waste of everybody's time. And I hate that expression when people tell me that we don't want to waste your time. Well, my time isn't being wasted. I get paid to sit in court, and that's that. So you're not wasting my time. But going up and down the lifts is a bit of a waste of time. They don't go very fast over my head. So be on time. Try not to be in two courts at once. Some judges will cop it, some won't. And if you happen to be for a judge who won't, you might well be disadvantaged. Outside of court, if you brought an outline, we'll talk about outlines shortly, make sure you give it to the other side before you come in. And that's especially important if you're dealing with a self-represented litigant. Give them your outline before you get into court. If you're going to seek leave to file a document, give it to the other people outside of court. I accept sometimes there will be a forensic advantage in not doing that. I accept that sometimes you won't have made a decision about whether to rely on something until you see how things develop inside. But most times, and certainly in relation to written submissions, you should exchange them outside well ahead of time so that the other side has plenty of time to digest them. And you might have seen my own practice in court. If somebody gets handed something at the bar table, I'll ask them if they've had time to read it. If they say no, I'll stand it down so they can. It's just courtesy to the other side from you as a practitioner to give them the things. It's not trial by ambush. It hasn't been for a very long time. And if your points are good ones, then you're not going to lose anything by giving the other side advance notice of it. So give them your outlines, give them your draft orders. If you're going to seek leave to rely on material, give that to them, all outside of court, well ahead of time. In our court, if you want to look at documents on subpoena, try and do that ahead of time. Of course, you can make administrative application to get leave to inspect, but there are always going to be documents to be looked at, in some cases, on the morning of the first court day. That happens. Different circuit judges conduct their lists differently. I'm sure you're all aware of that. And so outside the court, in some occasions, the associates for the particular judge will try and order the list and do that, whereas some other judges, like me, like to do that ourselves. We get people in, we have a call over, and we go through it that way. You need to know your judge. You need to know what the practice for that particular judge is. And you need to make arrangements as soon as you can to look at those documents that you're going to look at. There's no point when your matter gets called on for a hearing saying, oh, now, by the way, there's some subpoenas that we'd like to inspect, and can you stand it down while we do that? Again, you get the decision maker offside, you're behind the eight ball. You've had time to do that, you've and stood down till 12:30 or whatever you should have done. So talk to the associate if it's one of the judges who does the call over via their associate outside. Talk to the judge at the call over if you're before a judge who does a call over. Ask to look at the documents. Many people do. I'm sure you've heard it before, but make sure you do if that's what you need to do. So you would do that before you come into court. You come into court, and we won't go through my process of a call over. I'm sure you've all seen it. It's pretty straightforward. If you want to have matters stood down, as you know, there are arrangements to do that. She's late. That's it. You thought you'd just sneak in, didn't you?
I was trying.
Yeah.
That's right.
So you can ask for the matters to be stood down. I don't know of any judge who won't give you the opportunity to stand matters down to talk if there's some real prospect of things being sorted out. But again, do that as soon as you can. Do that as quickly as you can. Now, once you get into the hearing and the hearing commences, the first step in the process is announcing appearances. Pretty simple, really, isn't it? No, it's not. It's not. Believe it or not, it's not. So, your name and who you're appearing for. Barristers often will say that they're instructed by such and such firm. That's perfectly fine. It's required. But you need to say your name because everything gets taped. Back in the old days, before Ausscript and things were recorded, we had shorthand recording. You still see them in the state courts, I'm pretty sure. And so the shorties, as we would call them, would get everybody's name before the proceeding commenced. There was no need to announce your appearance in terms of what your name was. You could simply say, I appear for it. And in fact, I remember being told off by Judge Skane in the district court for announcing my name. Having done a week or so in the family court, I came to the district court, announced my name, and I was instructed by Joe Smith, and Judge Skane looked at me and said, so what? I don't need to know your name. I know who you are. Just get on with it, will you? See, I had a good teacher. So appearances, name, who you appear for. It's remarkable how many people forget who they're appearing for and who you're instructed by if you're being instructed, if you're counsel being instructed. Let the other side announce their appearance before you go on if you're for the applicant. Mr. McGrath, you wish to say something?
Just one before you. At the call over coming back,
yeah. I
often see where I always go to the bar table and it worries me that practically leave the bar table and things at the call over.
We'll talk about that.
Is that?
That's on the list. Appearances, let the respondent announce their appearance. Amazing. I mean, and I understand that people are anxious and ready to get going, and so people often forget. But try and remember, you've got to let the other side announce their appearance. The next step then is to let the judge know what you're doing there. And if you've been involved in a case for a while, or you've been working on this one all night, and it's all in your mind, and it's the only thing you've been thinking about, then you might forget that the judge has not seen it before, ever. And so what is what is old news to you is just brand new news to the judge. So you need to tell the judge what the case is about. And I don't mean that this is a parenting case or this is a property case, because we can see that from the file pretty quickly. It's written on the front. It is. It's written on the front. So we can see that. We really need to know what the case is about, what you're doing there. Your Honour, this is an application for inference name laws. That's what we need to do. And then when we've done that, we'll need to do some directions. That's it. This is an interim application for sole use and occupation. It takes a few seconds, but immediately you know. And it reminds you what you're doing there. People need reminding sometimes. So a quick like that. But the next thing then is the reading of material. And a lot of people don't seem to get this, and I don't understand why. The first thing you should identify is the document that brings you to court. Now, in our court, that might be an initiating application that has a request for interim orders in it. Otherwise, it might be an application in a case. In the federal court, it might be a notice of motion. I think that's not how it goes. In the family court, it might be an application in a case. But you should identify it because the judge will get it out, or the associate will get it out of the file and have it there. And then your affidavits. And you read your affidavits. Who knows why we read affidavits? Why do we read affidavits?
Once upon a time, you did read the affidavit from beginning to end.
Sure.
I think that's still left over from there, and you still say you read them, but that's the evidence you rely on.
Yeah.
So it has to go into.
That's it.
I was thinking just in case an affidavit hasn't been served on the other party.
Yeah. Well, there's two functions in getting them read in court. The first is to notify the other side of the evidence that you're relying on. And people often jump and say, hey, I haven't got that one. That's a new one. What are you doing there? Or alternative, and secondly, I should say, it's the way of introducing the evidence into the court. There's an old decision, which you might like to look up over your Christmas holidays, called Manson and Ponninghouse. It's a decision of the Supreme Court of Victoria, Chief Justice Madden. You'll find it in 1911 Victorian Law Reports 239. And in that case, His Honour, it was an appeal, and they were talking about what was in evidence and what wasn't. And the judge said this, the Chief Justice said this, it is true that the judgment debtor has placed an affidavit on the file, but his counsel has not opened it, preferring to rely on his objection to the judgment creditor's affidavit. He is entitled to leave his affidavit on the file, and until it is opened, it is not part of the proceedings. Now there he's talking about opening the affidavit. We talk about reading these days, but it's the same thing. It's on the file, but until you read it, it's not part of the evidence. And it's improper for a judge to go ferreting through the file, despite the fact that some do. It's improper to go ferreting through the file and read all of the affidavits. You read the ones that you're told to read, and that's it. The point you made is absolutely correct. If you appear in the equity division of the last time I appeared in the equity division of the Supreme Court of New South Wales, I was made to read the affidavits out loud from beginning to end. It was a bizarre experience. And I think in some cases they still do it in Victoria. I'm not sure about New South Wales. I've never seen it done in Queensland. But you're right, traditionally it was reading them out in court. And once it was read in court, it was part of the court record, part of the open record in court. And if it wasn't read, it's not in the evidence. So it's important that you read the affidavits that you wish to rely on. And you need to look out within those affidavits for references to other affidavits. Often an affidavit will start off by saying, I refer to my affidavit filed on such and such a date and rely on it, but it's not read in evidence. There are a couple of different views about whether the affidavit that's referred to is actually in evidence or not. The better course is to read it in your own list so there can be no mistake. So you read your affidavits. What do you do if you want to rely on an affidavit or something that's said in an affidavit by the other side? Any ideas? No? Don't read it. Because if you read it, it's your evidence. If you read it, and it's a sort of case where there has to be, or there can be cross-examination, you might be forced to call the deponent of the affidavit. And if you call them, you can't cross-examine them. You can only lead evidence in chief from them.
You might just make a submission that you understand certain facts are not in dispute.
That's the first thing. If things are not in dispute, then you're welcome to tell the court about that. If there are facts that are agreed, you can tell the court about that. But if you wish to rely on a particular part of the document the other side has filed, an affidavit or a financial statement, for example, then, well, first of all, let's ask this question. How is that admissible? You know those pesky rules of evidence? How is that admissible if you want to rely on something in the other side's statement, affidavit?
What authority until it's actually being evidence, right? And in cross-examination, you never know that's really what to the person during cross-examination.
Well, we're talking about a first court date, an interim hearing type of thing, where there's no cross-examination. How is the state, let's go back a step. Let's assume I'll get rid of the pesky parenting things. This is a property case, so the rules of evidence apply. The statement made by the other side in their affidavit, hearsay, not hearsay, what's the view? From your client's point of view, hearsay or not hearsay? It's hearsay.
Hearsay.
Yeah. It's a statement by a witness who's not, who you're not calling. It's a pretty loose description of hearsay, but that'll do for present purposes. It's hearsay. So how do you make it admissible in your case?
Hearsay though, it's interlocutory.
Oh, there's always a smart aleck. You're right. It is. It's admissible as hearsay in a interlocutory proceeding. Yeah, sure. How do you get it into evidence?
Subpoena the witness.
No. It becomes admissible, leaving aside the hearsay issue, it becomes admissible because it's a statement against interest. That's what that must be why you're relying on it, because it's a statement by the other side that's against their interests in favour of your client's interests, yeah? It's a statement about earnings or expenses or something they did in a parenting case or something they didn't do, but it's something that you need to get into evidence because it damages their case and helps yours. So it's admissible, apart from anything else, as a statement against interest. How then do you prove it? You prove it by giving to the court an extract of the document. Technically, you'd have to prove they made the statement, but you can hardly expect that the other side will dispute making the statement if it's in their own affidavits. So you produce an extract of it. And I think at the Law Society Symposium earlier this year, I gave the example of, or I gave the analogy of answers to interrogatories. Who's ever seen answers to interrogatories? Gee, you're old.
Thanks.
Interrogatories were questions delivered by one side to the other. And they're referred to in the family law rules, I think, and in our rules, although not in our act, as answers to specific questions. Interrogatory sounds much more listed. And people would answer them. They had to answer them on oath, and you'd go through each one. And you know, many barristers made their career out of objecting to answering interrogatories. It was a very technical thing. But you would ask the questions to get the admissions that you could rely on at your trial. And so the way you proved the admissions was to extract the question and the answer, and you just had it on a separate piece of paper. You didn't want all the answers to interrogatories in, because most of them helped the other side, not you. But you weren't required to tender them all. You just were required to produce the admission, the statement against interest that you relied on. And the principle is the same here. If there's something in an affidavit, you don't want the whole affidavit in. You don't want to have to call that witness. You don't want to be denied the opportunity of cross-examining. So you produce the extract of the evidence. Or, alternatively, and I accept that things develop quickly in duty lists, you might simply say to the judge that you wish to refer him or her to paragraph X in the affidavit, but don't read it. You just want, that's the bit I'm relying on, and I'm relying on it as a statement against interest. Can you get it out and have a look at it? That comes into it, it's evidence, you've relied on it, the judge has it, the rest of the evidence isn't in, and you haven't compromised your ability to cross-examine the witness in, say, a spouse maintenance case. I had an opponent once read my client's financial statement in a spousal maintenance application before Registrar Spellican, as she then was. No, Registrar Dittman it was. And we were all a bit taken aback by that, but I then asked to cross-examine the deponent of the financial statement. And when we all realised that the financial statement was in fact an affidavit, Registrar Dittman had great delight in letting me cross-examine my own client. The other side had read his financial statement. He was then their witness, and I got to cross-examine him about how much money he didn't have. So those things are important. So that's about reading affidavits. Read the ones you want to rely on. Don't read your opponents. Extract the bits if you've got the time. Tender them, and that's the way answers to interrogatories used to be dealt with. They were tendered and received into evidence, marked as an exhibit. And you should do that as well. I skipped over a really important thing about announcing occurrences. I'm sorry, I missed it. Who says good morning? Who thinks it's a nice thing to do? It is a nice thing to do. Is it right?
No.
Why do you do it?
They do it in the magistrate's court at Southport.
Yeah. Why do you think it's a bad idea? Yep. Sorry? He said it shows too much of a familiarity with the judge. We'll talk about we'll talk about
I could just have that.
I've never taken it off anybody. Despite rumours to the contrary, I have never put a solicitor in jail for it. Yet. So familiarity between the counsel and the bar. Any other reasons?
Perceived bias.
Perceived bias, yeah. There's a decision that it's worth reading. It's called Wilson and the Department of Human Services. Re-Anna, it's called. 2010 NSWSC, New South Wales Supreme Court, 1489. And it's worth reading this. This is Justice Palmer of the Supreme Court. And these are in proceedings, care and protection proceedings, where a child has been taken off the mother by the department down there. And His Honour says this. The second matter calling for comment, this is quite long, but it's really worth listening to. The second matter calling for comment occurred in the conduct of the case in this court, but it is not peculiar to this case. It has been observed by a number of judges in the Supreme Court, and it is currently the subject of discussion between this court and Bar Association and the Law Society. I refer to the practice of advocates, which seems to have developed over recent years of announcing their appearances to the bench or beginning the examination of witnesses with the salutation, "Good morning, Your Honour," or "Good morning, Mr. Smith." I'm informed that this is a practice which has developed in the Magistrates Court. The Supreme Court is of the view that this is a practice which should be abandoned in contentious litigation. Lest it be thought that this view is a relic of a stilted and now outdated judicial self-esteem, let me illustrate by reference to what occurred in this case, how the practice can cause substantial misperceptions prejudicial to the conduct of a fair trial. Mr. Chapman, who is obviously a highly experienced and capable solicitor frequently conducting cases in the Children's Court, routinely greeted me with the salutation of "Good morning, Your Honour," or "Good afternoon, Your Honour," each time he announced his appearance at directions hearings and on each day of the trial. In accordance with the usual etiquette of this court, Mr. Moore of counsel did not. Mr. Chapman's apparent familiarity with the judge could have caused a misapprehension in the mind of Ms. Wilson, already distrustful of the judicial system. This is a woman who had her child taken away from her, 2 days after birth, I might add, that Mr. Chapman enjoyed a relationship with the judge which was something more than merely professional. Such a suspicion should never be allowed to arise. A judge should not feel compelled to allay such a suspicion by rebuking an advocate for misplaced courtesy. More importantly, Mr. Chapman routinely began his cross-examination with the salutation, "Good morning, Mr. Wilson," or "Ms. Wilson." He was met with stony silence. How could Ms. Wilson or Mr. Wilson greet politely the man who was avowedly intent on taking Anna away from them by destroying their evidence? A witness in their position would inevitably feel it was to be the most odious hypocrisy to be compelled to return the salutation with a polite "Good morning, Mr. Chapman." Mr. Chapman, of course, noted the rebuff and on occasion directed a meaningful look at the bench. I do not think he intended it, but the impression which could well have been conveyed to Ms. Wilson and Mr. Wilson was that, even before Mr. Chapman had begun his cross-examination, he had already unfairly scored a point against them because he had put them in the position in which he could say eloquently, by a look, not even a word, "You see what rude and unpleasant people we are dealing with here, Your Honour." I wish to make it clear that by these remarks I intend no personal criticism of Mr. Chapman. He conducted the case professionally and courteously. However, a witness should never be placed in a position of having to greet politely a cross-examiner who is an avowed opponent. An advocate should never use this technique to score against a witness. It is far better to avoid the perception that this technique of discrediting a witness is being used unfairly. For these reasons, the practice of salutations by advocates should be completely abandoned in all courts, in all contentious litigation. So, there it is. It's nice to be nice, but there's an excuse for not being nice. It's the one I'm sticking to. Right, so we've talked about identifying your material, affidavits, and cross-affidavits. What about subpoenaed documents? What do you do with them? You've inspected them, there's some gold in the department's file or whatever. What do you do with that?
Tender into evidence what you want the judge to look at.
Is that all? Shouldn't the judge have the whole lot?
He won't read them.
Correct. Just won't read it. And it's improper. It's just as it's improper for a judge to go ferreting through the file, it's improper to go ferreting through the subpoenaed material. That doesn't stop some, but it doesn't mean that it's right. If you want to rely on subpoenaed material, you tender it. And you don't ask the judge if they want you to tender it. You're the one running the case. You either want it in or you don't. And if you want it in, you identify it and you tender it. Now, there are difficulties, of course, with documents that are produced on CD. And those documents really ought to have been inspected before the day that you're in court and copies requested or whatever. But if there are documents on the CD that you wish to tender, then make that known as soon as possible, because the court can make arrangements for those documents to be available one way or another. But don't leave it till the last minute. And be sure of the documents that you want to identify, you want to tender. In a bundle produced from the police or wherever, have them flagged, have them tagged so that you can refer directly to them. It's awful to be handed up a bundle of material to be tendered and to say, well, I'm not taking any of that. You need to identify the documents you're relying on, and then people scramble through the documents and it takes forever. And again, the person that you want to think that your client is the good guy and the other guys are the bad guy, and you're trying to do the job of persuading the judge to make the orders that your client wants to make, you've got them offside. It's all about persuasion. Once each side has announced their or given a list of material, that's the time to hand up the written submissions. Sometimes people put a list of their material as part of their submissions. That's okay. You can hand that up all at once. Your Honour, my material's in my written submissions. I'll bring it to the other side. I've got a copy for you. Some judges like a working copy. I don't particularly need one, but it's always nice to have two because some judges do take a working copy. So have two ready and hand up your submissions. And then when the judge is ready, he or she will invite you to make the submissions usually. I don't need to tell anybody here, I don't think, that you don't need to read your written submissions to the court. Plenty of people do, and plenty of people insist on doing it even though you say, now listen, I've read that, or I've read the bits that I need to read or I want to read. You don't need to take me through it. Anyway, people do. If the judge asks you not to do that, don't do it. Again, for no other reason than they're the last person you want to get offside. You want to stay on their good side. And it's not really about pandering to the judge. It's just about being efficient and listening to the cues that you're getting from the bench. The judge wants to do the job correctly. Nobody likes to do a shoddy job. In a busy list, there's limited time, as you all know. There's limited time. The judge is trying to think quickly, so they might be a bit more ahead. These are the things they're thinking about. They want to hear about that. Deal with that when the judge wants to deal with it. Come back to the things that you want to deal with later. You'll be given an opportunity to do that, usually. But deal with the things the judge is talking about when the judge talks about it. Because they're thinking about those things then. And that's your opportunity to deal with it, to turn their mind then about those issues. But what about this point? Or can I come back to that? Well, okay, but gee, I'm thinking that point's not going to help your case, and it's really something that's going to determine it against you. But if you really want to talk about it at some other time, that's fine. And then people sometimes forget to come back to it. And if the judge doesn't prompt you again, then you've lost your opportunity to address it. But because things develop quickly and like that, you might be caught off guard. It's going to happen. In those circumstances, there's nothing wrong with saying to a judge, I haven't thought about that. I just need a moment. And if you need more than a moment, and you need 5 minutes, say so. I don't know any judge who will say, no, you can't have it. Plenty will, maybe express a little bit of dissatisfaction if you haven't thought about it, because, what do you mean you're not as smart as I am? But nobody's going to say to you, no, you can't think about it, or you can't get instructions, or you can't whatever you want to do. Unless you've done all those other things I said you shouldn't do, and you've really got somebody else on. So, if a judge throws a question at you, asks you to do something or not do something, do it, deal with it then. If you haven't got the wherewithal to do it, deal with it on the spot, ask for some time to think about it. And that might mean standing it down until the next matter's finished. Same goes for questions about authorities and statutes. Don't guess. Some people like to guess, and it's not helpful because the judge who makes the decision doesn't want to get it wrong. And judges often ask questions about your arguments and ask questions about authorities and statutes because they want to get it right. And they're testing your argument. Justice Byrne once said to me, the birds don't pick at the bad fruit. I thought it was a kooky thing to say, but after a while I understood. If a judge wants to make the orders that your client wants to make, they want to make sure they're going to get it right. They don't want to be taken upstairs on appeal and shown up for being silly and have the appeal alone. So if they're going to test your arguments. They're going to test your reasoning process so they can satisfy themselves. So that's why it's important to deal with the things when they're asked. And if you can't deal with them, particularly issues involving statutes and authorities, you might need to stand down. I haven't read that case yet. There was a judge, a very famous judge here in Brisbane, who used to ask counsel about cases, about the latest decision from the Court of Appeal on XYZ or from the High Court on XYZ. And sometimes counsel would say, oh, yes, Your Honour, I've read that. Well, that's interesting because they only handed it down at 10 o'clock this morning. And you've been here since 9:30. Be careful of that. There was one judge, I only know of one judge who ever did that. But he would never forget. If you fell into the trap once, you'd never forgot. I didn't fall into the trap, just for the record. But I know some who did, and he never forgot that. So if you need some time to look at an authority, fess up, I haven't read that. Great. Well, do you want some time to read it? Good. Off you go. Come back and talk sensibly to me about it. Don't try and make it up. So, adjournments. Asking for adjournments. If you're going to ask for an adjournment, asking for an adjournment is a bit like voting. Do it early and do it often. if you're going to ask for an adjournment, the minute you walk into the court, after you've announced appearances, ask for the adjournment then. Don't let us go through half an hour of what the case is about, because sometimes that's what it takes, to then say, but what we really want is an adjournment because all this other stuff's happening. Start off by saying, in that little 10-second bit where you say, Your Honour, this is an application for interim parenting laws about how much time these children are going to spend with their dad. Your Honour, the first thing we need to do is an adjournment application. My friend wants to make an application for an adjournment. Is that right? Yep, right, let's hear it. Or I have an application for an adjournment. Or we're agreed on an application for an adjournment. Whatever. So raise that straight away. Make sure you have a good reason for your adjournment, of course. Adjournments, well, depending on where you are, I suppose, adjournments generally aren't given for the asking. So have your reasons all sorted out. And like I say, if it's not agreed, say that the other side's going to ask for an adjournment and the court will try and get that out of the way. Making submissions, oral submissions. Who's sat in court and seen me say, I don't really care what you think? Or what, yeah. I don't know, do they still teach that in law school? That really when you're making submissions on behalf of your client, your opinion as a lawyer is irrelevant? Yeah? It was drummed into us at the bar practice course when I did it. But, and thereafter in some other places. The court's not interested in what you think, what you believe, what your opinion is, none of that, even though you might get asked from time to time, what do you think about that? The court's interested in your submissions. And you might think it's pedantic, but it's not, because your opinion might be completely different to what it is that you're submitting on behalf of your client. And whether you believe in your client's cause or not, by giving me your genuinely and heartfelt opinion about it, is really neither here nor there. And if we operated in any other way, we might have people making submissions that I trust inherently as lawyers, and they're giving me their opinion. I'm going, well, that's a crap case then. If they're saying that their client's case is terrible, well, probably is. Or it's you see the point. Your opinion is not really important to the court. Important to your client, not to the court. I've left an authority at home talking about opinions to clients. There's a decision of Justice Muirhead, which is in a case called Mason, and I won't get the last name right, Pollinghausen, I think, was the name, Pollinghausen, 1977, 31 Federal Law Reports, page 298. And I only know that because I just gave it to some solicitors in my duty list. I mean, literally gave it to some solicitors in my duty list about 3 hours ago. And there's a practice, and there's a passage in that from Justice Muirhead. He's talking about the old matrimonial, I'm pretty certain he's talking about the old matrimonial clauses legislation, but it's equally applicable to family law legislation. And he talks about the duty of solicitors and counsel in parenting and property cases in the family court, family jurisdiction, and about how you are not mere mouthpieces. You are not puppets of your instructions. And he makes the point that your job is to advance your client's interests through advocacy and to assist the court. So standing there and saying, my client would like week about with these children and they're my instructions is not helpful at all, in the least. Not one iota. Can I make it any clearer? Not helpful. What is helpful is, Your Honour, my client submits that orders for time about, week and week about, are in the best interest of these children because, and then you be an advocate. You start to persuade because These children have a meaningful relationship with their father and their mother, and that's established by the affidavits. It's not in dispute, and that will keep it going. There is no assertion by either party that these children are at risk of harm and the care of either parent. That's another reason why it's appropriate. It's consistent with the objects and principles of the Act. These children are expressing wishes to spend that sort of time with my client. That's not my client's evidence you've got to rely on. That's what they told the family report writer in the 11F consultation this morning. And you advocate. You don't just stand there and say, well, they're my client's instructions. It's in the best interest of these children that you should make these orders and not those because that's what my client believes. That's not advocacy. So avoid the use of the words, I think, my opinion, or certainly I submit, but you need to back it up with some real advocacy, with some reasons. You're not simply there to tell me what your client's instructions are. On that point, often people will talk about, well, when they make their submissions, Your Honour, we submit. Is that appropriate? We submit? This is again one of those silly old rules, but, you know, keeps people amused, like me. We submit. Only silks say that. Only silks and juniors who are appearing with Queen's Counsel say we, because there are two of them. Or if there are two counsel, we submit. But if you're a solicitor appearing for your client, it's not we, it's me. It's I. Same with counsel, junior counsel on their own. It's I, not we. We is reserved for silks appearing with juniors, or juniors appearing with silks.
Excuse me, Judge, what if you're appearing for the ICL? Can you say we be?
No.
No? Okay.
Unless you're led. If you're being led, you could, but otherwise, no. You're the counsel, you're making the submissions, I submit. And who here gets across the road to the Supreme Court and District Court? There'll be plenty of people who do that, no? None? One? Two? Yeah. Try doing it over there and see what happens over there. I dare you.
In the event that all of the solicitors hearing have come to a consensus about what ought to happen.
Yeah.
For example, consent directions.
Yeah.
Is it appropriate to say it is we submit, as in all of us submit that?
Oh, if you're talking on behalf of all of the solicitors, yeah, sure. But I'm talking about making submissions for your client. Yeah. No, that's fine. You know, if you're talking collectively as a group. What is a group of solicitors? I know. Okay, so we're talking about making submissions. How's the time? What's the? Okay. We're talking about making submissions. Don't interrupt. Plenty of people do, and it's really discourteous. In a duty list, you can't object to the submissions the other side of that. They're submissions for crying out loud. You object to evidence, but you don't object to submissions. You might think the submissions are wrong, but you'll get your opportunity to say that they're wrong. If you're the applicant and you've already gone first, you've already had your say, and the respondent's saying some silly things, you're generally invited to reply. Save it for the reply. If you're the respondent and the applicant's saying silly things, or misstating the evidence, or saying stuff that isn't in the evidence, just wait your time. If you stand up and interrupt, you might get the judge offside. And think about the forensic impact of it. Think about the forensic impact of being able to stand up as a respondent and say, well, Your Honour, the applicant's talked about this, 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 and this. There's no evidence of this, 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 and this. So you can put all of that to one side. Let's talk about what the case is really about. And without all of the drama, without getting the judge offside, you've dealt with their case. I mean, you're not going to be able to do that every time, of course, but think about that. You can turn it to your advantage. You know, we've sat here for 10 minutes listening to this, but really, there's no evidence to support any of it. There's nothing in the affidavits, nothing you've been taken to. This is what this case is about. Don't interrupt. Don't interrupt. What else? What else do I want to talk about? Oh, there's a couple of things we'll come back and talk about, but at the end of the interim hearing, you've made your submissions, the respondents made their submissions, the applicants had a reply, and the judge has given their judgment. The judge hasn't covered all of the arguments that you've made. What do you do? No idea? Or you just not going to say?
Is there anything else?
Well, if there's an important argument that you've run, which you think is maybe the seminal part of the case, and the judge hasn't dealt with it at all, you can stand up and ask the judge to deal with it. Your Honour's reasons haven't dealt with this aspect of the argument that I made. Does Your Honour intend to deal with that? That's probably as gently as you can say it. And you'll get a yes or a no. Polite, maybe, I don't know. But you've raised it. And why is that important, do you think? Yeah, it's important if your client wants to appeal. It's important for two reasons. First of all, you might find the Court of Appeal says, well, hang on a minute, the judge didn't rule on an argument, but you didn't take it up with him. And secondly, you might want to run an argument about lack of reasons. Well, you didn't ask for reasons on that. So that's not going to happen in every appeal court. Some appeal courts will get your point. But do you want to run that risk that you spend all the money on the appeal and you get up there and the judge says, hang on a minute, you didn't ask about that. Better to do it. But do it politely. Do it politely. What about orders? What about if the judge doesn't make an order that you asked for that you say is important? What do you do then? Come on, it's not hard.
Well, pretty much the same thing.
Yeah, same thing, exactly. Stand up. Your Honour didn't make an order about this. You'll either be told I don't intend to, or I'm sorry, I've forgotten. Let's do it. You know, but you're protecting your client's interests. But you need to do it. You know, courteously. What about if you don't like the judge's reasons? What do you do then? Oh, come on, it's not that hard.
Ask for a bit more reason.
No, you've just got the judge's reasons. What do? Nothing. You appeal if you don't like the reasons. And that's all you can do. As long as the judge has covered the arguments that you've made, then you can't argue with the decision, except to take it on appeal. There are some little aspects in the rules that you should familiarise yourself with. Rule 16.05 is a cracker of the rule. When you read it, you'll see that if there's an interlocutory order that you're not happy with, you can actually ask for it to be done again in certain circumstances. So have a look at that rule. It's an interesting little rule. But subject to that, if you don't like the judge's reasons, really your only recourse is to appeal. But an appeal, of course, is not against the reasons. An appeal is against the orders that are made. Now, so the judge has given his judgment or her judgment. She's delivered the reasons, delivered the orders. It's all over. What do you do then? Mr. Maguire, what do you do then? No. Correct. Ask to be excused. No, you don't. Who said that? Who started this heresy about asking to be excused? You don't. I've taken a poll of judges around this town about this. You don't ask to be excused. It's the height of rudeness. You stand there until the judge excuses you. And if he doesn't or she doesn't notice you for 5 minutes, too bad for you. It's true. That was the old etiquette. You never leave the bar table unattended. If you're the last person to occupy the bar table and your case is finished and the next person is in there, you stay there. And you don't ask to be excused. If the judge notices you, he or she will generally excuse you. There's no need to wait. Thanks for your courtesy. But gee whiz, don't ask to be excused. It's very rude.
just one point on that. I was briefed the junior counsel and he turned on his ear and walked straight out of the court after the matter was done.
I got his name.
But I stopped him, outside court and I said, you don't do that. And he said, we were told to do that at the bar practice.
Really?
Yeah. I was corrected him to say, you before you.
Yeah.
But it's something that annoys me. I see it. In fact, I saw it only today again. Where you stand there and you're left sort of like a shag on a rock. And you are. I mean, the other counsel, the others just walk off. And you're left there waiting for the next matter to come on.
And I'm not making, I mean, Steve Maguire is old enough to know. I'm not making this up, am I?
Absolutely not.
No, see, I'm not making it up. Stay there until you're invited to leave and don't ask to be excused. I've refused it a couple of times. It was a slow day, you know. Can we be excused? No. And you can see them going, oh, what do we say now? Do we ask for reasons? But, you know, the etiquette is you don't ask, you wait till the judge excuses you, and then off you go. And there shouldn't be a problem. So that, and the same in the call-over. Call-overs are a bit different. The etiquette is, of course, that barristers sit at the bar table and solicitors don't. But there are plenty of solicitors who like to sit at the bar table for reasons of self-amusement. So I've got no problem with that. But in a call-over, leaving the bar table bare is not such an issue because a call-over is really an audience within the whole court and there are people there everywhere. So I wouldn't be too concerned about leaving the bar table free in a call-over. But when your matter's finished and you're waiting for the next one to come in, don't go. Just stay. What else? What else?
Joe,
Yeah.
just for clarity though, people don't get confused. Once people actually walk up to the bar table.
Yes, yeah. It's just no, we don't want everybody there. It's not like, it's not like England in the 16th, the 17th century where they're all crowded around and everybody's waiting to get a brief. No. Once somebody arrives at the bar table, you can go. You don't need to be told to go. You just turn around and go. A miscellany of things. Always have draft orders if you can. Not many people bring draft orders. Some people do. Those that do generally win the prize. Yeah. Think about it. The person you're trying to persuade, they've got a beautiful set of draft orders from one side and none from you. Oh, what orders do you want? What is the order you want me to make? It's in the application. Yeah, but we've gone through that. That's terrible. Yeah, I know it's terrible. What orders do you want? What about these ones? These look really good. Do that. Have a draft order. Yeah. What about direction? I do, but you see, one of the complaints about the Federal Circuit Court, particularly in the first 5 years it was around, was that we all did things differently. The complaints have tapered off, but that's, I think, because people realise they can't do anything about it. We all do things differently. It's lovely to get a set of directions, but unless they're the directions that suit the case, they're no good. There are some judges in courts, and it's not just the Circuit Court, it's across all courts, who like to use a standardised form of directions order, if you like. And they're made in most cases. And there are other judges who don't. I think I'm one of those. I don't like using standard form orders. I have a standard form of order for particular things so that across all of my orders for the appointment of an independent children's lawyer are consistent, hopefully. And all of my orders for drug testing are consistent. But I don't have a set of standard directions made in a parenting or property case in the first court date. And that's because those of us who do it that way try to avoid the system being process-driven and more outcome-driven. What's the issue here? I'm sure people would have told you that that's what I say in court. What's the issue? And I'm not talking about the outcome the difference in the orders that the people are contending for, but the issue that holds them apart. What's the issue? And if you identify the issues, then you can make directions that deal with those issues. So in a parenting case, drug abuse. Is your client taking drugs? Yes. Great. That's that issue dealt with. No, right, well, we better get some drug testing done so that we can put that little issue to bed. Alcohol abuse, blah, blah, blah. So this goes on, but identify the particular issues and then make directions to cover off those issues. In a property case, valuations, you know. And plenty of people get the idea now. They come in, we've agreed on a value to value the former matrimonial home and the, you know, Coke bottle collection. We've done that, and that's going to advance the case because they're the two things holding us apart. Once we get the values sorted out for that, we're pretty much home and hosed. Whereas, you know, I can tell you stories or not, but you get cases where you get the standard orders presented to you and people haven't thought about the issues, and when you walk them through, you get to the end of that process and there's nothing left to argue about. We've certainly had that happen, where they say, hang on a minute, we want 60% and give them 40%, and they're saying, we want to give you 60%. Don't we disagree on the value of the house? What is it, 380? We're 380. It's happened. So, righto, I've said lots of things. Bring your rules to court, by the way. Bring your rules of court to court. Everybody's got iPads these days. It's pretty easy. Do that because you'll get asked about the rules and you need to use them. You need to be able to tell the judge where to look in the rules for whatever it is that you need to do. Who's in my duty list tomorrow? Bring your rules. There's a couple of other things I got down here. Mobile phones. I've not seen a solicitor to jail. I want to deal with that rumour. I have not done that. Thought about it, but I haven't done it. I once fined a person for having the mobile phone go off, but that was after I warned them twice that they should turn it off. And they lied to me about why they didn't turn it off. So I fined them $250. No, not because you can, because it was important. Why is it important, do you think? Why? I mean, it's a silly rule. Everybody says, oh, what are you, mobile phones, what are you worrying about that? Why is it important to have them off in court? Yeah, leave that aside. Don't worry about me. Worry, what? It's disruptive. Oh, does it? Okay. I didn't know that. But your clients are paying you to be there, right? You know, somebody told me today they were getting charged, they were getting paid $400 an hour to be there and argue a case for their client. If you were that client, would you want somebody's mobile phone going off and interrupting the flow of your solicitors or your barrister's persuasive speech to the judge? No. It puts people off. You know, quite frankly, it doesn't concern me that much. It's disrespectful, but yeah, I get over that. There's a lot of things that I do that people think, you know, anyway. But it's disrespectful to the people at the bar table, the people who are paying big money sometimes to be there and who are doing their very best to present their cases, and they get interrupted mid-flow by somebody's mobile phone ringing in the court. That's why it's important to have them off, because people expect to be given a proper go in court, and it doesn't give them a proper go. It disrupts the flow, it distracts their advocates. I've had people lose their train of thought because it's happened, and it's disruptive. So it's not about the court, really. It's about what's happening in the world of the court. So that's mobile phones. That's about it, really, that I wanted to talk about. Do you have any questions? Yeah.
When we were talking about announcing appearances earlier, at a call over, should we do that formally? I
No.
think some people just say,
Yep.
the applicant or one.
Yeah. Who here had the great pleasure of doing a call over before Justice Shepardson, Tom Shepardson in the Supreme Court? Really? Nobody? Okay. Tom Shepardson would come in and he'd say, I'm conducting a call over. I want time estimates. I want realistic time estimates. And so he'd call the first matter, and the first person would come up to the bar table and say, Your Honour, this is an application for injunction. I said time estimates, you're at the end of the list. Then he called the next matter. And somebody would go up to the bar table and say, Your Honour, this is an application for the time estimates. You're at the end of the list behind that first one. And that was it. A call over is intended to be snappy, short and sharp. What's this about? What's this about? You're directing traffic, really. You want to be stood down? Good, get out. You don't even, if I stand you down, don't stay in the courtroom. Go outside and do what you've got to do. That's why we do that first. Get outside. Don't really want to know who you are. I want to know who you're appearing for the applicant, for the respondent, great. What's it about? How long? 10 minutes, great. That's it. Call over is not a formal thing. It's just an ordering of the list. It's directing traffic, as I said. Anything else?
What happens if you're grossly wrong in your estimate of time?
Nothing. Nothing really. I mean, once you start, you keep going until you're finished, unless you've done lots of other things wrong. But no, seriously, nothing. Trust me. So, anything else? See, I mean, it's
estimates for trial.
Estimates for trial. I mean, how long's a piece of string? The judge will sit there and go, "Oh, you've got to tell me how long the trial's going to take," and blah blah blah. And I do that myself, but I've been a barrister. I know that you can't predict with any reasonable degree of accuracy how long the trial's going to take, because witnesses do all sorts of things. Judges do all sorts of things. All sorts of things happen. Giving an estimate for a trial is a necessary thing because the judge has got to manage his or her diary. But what happens if you don't comply with your estimate? The case either goes part heard to another day, or the judge keeps going, or you finish early. Sometimes people overestimate. Any other questions? No. Right. Well, I hope that's been reasonably helpful. Yes.
Could everyone just join with me firstly in thanking Judge Jarrett for donating his time and coming and joining us this evening. I certainly think it's a testament on behalf of everyone here and all the Flipper members who are joining us on webinar that none of us want to do a shoddy job, and that's why we're all here. And the idea of having a discussion with the judge, because they don't want to do a shoddy job either, and having your argument tested makes the concept a little bit easier to digest. In relation to His Honour's threat that he could tell us stories all night, it's hoped that he will join us for a drink at Brew afterwards and follow through on that.
Sure.
And you're all excused.